Hey guys, welcome to my legal classes. This is Ganesh Pujari, and by now you know that to understand every single term in Industrial Dispute Act, we have lot of case laws. While understanding what is industry in my previous lecture, we have seen lot of case laws and understood how exactly this has come to a term. Likewise, it is very interesting to understand what is industrial dispute and then what is individual dispute. There is one beautiful amendment also available when we are discussing these particular aspects, and here I am going to focus on two important sections, that is section 2K and the amendment section, that is 2A. Why to waste time? Let's get into the first slide to understand what is industrial dispute. As I have already told, section 2K defines what is industrial dispute. Industrial dispute is a dispute which is a dispute or difference between employer versus employer, employer versus workman, or workman versus workman. Remember, it is not just dispute, it might be dispute or it might be difference. Now, if any dispute or difference happens between employer versus employer, employer versus workman, or workman versus workman, which is connected. Now, not everything in this world will become the industrial dispute. If the matters which is happening between any of these three, which I have already told, if the topic is related to employment or non-employment or terms of employment or conditions of labor, then we are calling it as industrial dispute. So it happens between employer versus employer, employer versus workman, or workman versus workman, and the topic should be connected to employment, non-employment, terms of employment and conditions of labor, and the definition ends with of any person. Now, who is this any person? That part I am not touching right now, that I am keeping pending. When we are discussing case laws, I will explain more on that particular aspect. Few important aspects that you need to remember is the term employment and non-employment includes retrenchment as well as refusal to reinstate, and likewise industrial dispute doesn't always means that it is the dispute between majority union or recognized union versus employer. It can happen with minority union also, or it might happen with other workmen also. That is also we need to keep in our mind. And when I am saying the term of employment or the conditions of labor, I have already explained in my single slide video what are the different issues that we are covering under industrial dispute, like for example wages, bonus, profit sharing, gratuity, compensation and other allowances. Likewise, holidays, leave with wages, hours of work is also considered, or it may be related to retrenchment of workmen or rules of discipline, closure of establishment, nationalization, transfer, or anything that I have already explained in my single slide video. These are the aspects we need to remember. Then comes the amendment section, section 2A. Remember, till the year 1965, that means till the amendment section 2A came into existence, there were a lot of discussion on what is individual dispute and what are industrial dispute. Can an individual dispute can be considered as an industrial dispute? Now, there were a lot of case laws, lot of interpretation to understand whether an individual dispute can be treated as an industrial dispute or not. Now, case by case, there were a lot of interpretation and there was still confusions. But then, as I already said, in the year 1965, section 2A came into existence, which gave a lot of clarity on when an individual dispute can be considered as an industrial dispute. That is what exactly defined under section 2A, and let us try understand the provision. This section is very easy. It says if an individual dispute is related to or connected with or arising out of any dismissal or discharge or retrenchment or termination, in that case such individual disputes shall be considered as industrial dispute. It is not maybe or can be, it is shall be. That means the court should consider such individual dispute as an individual dispute. When an individual dispute is related to or connected or arising out of discharge, dismiss, retrenchment or termination. In that case, an individual dispute becomes industrial dispute. And remember, here a workman alone can fight. WORKMAN. It is singular. A workman can alone fight his case. He need not to have any support from any other workman or union. He alone can fight his case, and even then, if they are related to discharge, dismiss, retrenchment or termination, in that case, they will be considered as industrial dispute. Now that we know when can an individual dispute can be considered as an industrial dispute. Now I am giving certain amount of additional information which is in green box. Remember, if you want to go for a remedy with the employer for an individual dispute which has all the content required for industrial dispute as discussed under section 2A, then first you have to get the remedy, or you have to attempt for the remedy from the employer. You need to make an application to the employer to give remedy to you. Now, if the employer is not bothering to your application, in that case, you have to make an application to the conciliation officer. Once the application has gone to the conciliation officer, he need to address you within 45 days, and if he is not taking any decision, then you can directly apply to the labor court or industrial tribunal for adjudication. Now, one important thing that you need to remember is when you are making an application to the labor court or industrial tribunal, there is a time limit. You have to make the application within the 3 years of date of incident. That means whatever date the discharge or dismiss or retrenchment or termination happened, within 3 years from that particular date, you have to make application to the labor court or the industrial tribunal. That is the time limit you should always remember. So far so good. As of now, we are very clear with all the aspects that we have discussed under section 2K and 2A. Under 2A, now we are very clear that if an individual dispute related to or connected to or arising out of any kind of discharge, dismissal, retrenchment or termination, then it shall be considered as industrial dispute and a single workman can fight his case. That's very clear. My question is, what if the issue is not connected to discharge, dismissal, retrenchment or termination? In that case, can an individual dispute become industrial dispute? For that answer, forget all the colored boxes. Now come to the plain box which I have kept in the last part of this slide. Here again I am referring section 2K. If the matter that is happening with an individual employee, if it is related to employment, non-employment, terms of employment or conditions of labor. Remember, all of these terms are coming from section 2K. Now, if it is related to employment, non-employment, terms of employment and conditions of labor, though it is an individual dispute, if there is substantial community of interest or collective will, that means lot of workers are supporting or the union is supporting, and if it is supported by appreciable number of workmen, there is no such number which is considered as appreciable number of workmen. It has seen case by case, and if the union is supporting it or if it is a consulted demand, in that case, when all these people are in support of aggrieved workmen, in such cases, it is also considered as industrial dispute. So, when an individual dispute related to employment, non-employment, terms of employment or conditions of labor, and majority of the workmen are supporting the aggrieved workman, in that case also individual dispute becomes industrial dispute. I hope that is very clear. With that, I am taking you to case laws. When it comes to case laws, the first important aspect that we are going to understand is who has the jurisdiction of industrial disputes. whether it is civil courts or the industrial dispute authorities like the labor court, industrial tribunal, etc. Now, if you are a law student, you understand what exactly is the term meaning of jurisdiction. When we are discussing about CRPC, CPC, etc., we know that there are different types of jurisdiction which mainly can be divided into four categories. The first one, that is pecuniary jurisdiction, which is related to financial aspects. Then we have subject matter jurisdiction, which is mainly on subject matter. For example, the industrial tribunal is for the industrial dispute, not for any divorce cases. That is how we are seeing subject matter jurisdiction. Then we have territorial jurisdiction, which is basically depending upon the geography. For example, district courts are for a district, high court for a state, etc. And then we have original and appellate jurisdiction. Original jurisdiction is the capacity of a court to take the case, whereas appellate, one court has already heard the case, but another court has the power to hear the same case again. That is called appellate jurisdiction. Now, these are the four different categories of jurisdiction, and here when we have to answer this particular question, that who has the jurisdiction to handle industrial dispute, we have to focus on subject matter jurisdiction. If the dispute is related to industrial dispute as defined under section 2K or 2A, then they will definitely go to industrial dispute authorities like the labor court, industrial tribunal, etc. But before going there, we need to see the four important essential. One, the factum of the case. Second one, the parties of dispute. Third one, what exactly is the subject matter. Fourth one, origin of the dispute. And if all of these are coming under the premises of industrial dispute, then it is definitely with the industrial dispute authorities, or the jurisdiction will always be with the industrial dispute authorities. So I have three case laws here. The first one is Chandrakant Tukaram Nikam versus Municipal Corporation of Ahmedabad, where a particular employee got dismissed, and it was held that dismissal or removal from service is an issue of industrial dispute, so it should always go to labor court or industrial tribunal. Likewise, the RSRTC versus Deen Dayal Sharma, where a conductor got terminated for not issuing the ticket, here also it was decided that it is not a case which need to be dealt by the civil court. It should go to the industrial court, that is labor court or the industrial tribunal. And then in the case law of Premier Automobiles Limited versus Kamalakar Wadke, it was held that if the matters are defined under ID Act, then it should always go to industrial dispute authorities. Whereas if the matter is not defined, in that case the choice is available whether to go to the industrial tribunal or labor court or to the civil courts. And it was also suggested that if the issue is substantially connected to the industry, then it is always better the parties go to the industrial tribunal or labor court. These are the three important case laws you can refer as far as jurisdiction of industrial disputes are concerned. Now let us try understand the disputes related to contract labor, whether they can be considered as industrial dispute or not. I have two case laws. The first one says no, the contract labor disputes cannot be considered as industrial dispute, whereas the second one says yes, the contract labor disputes can be considered as industrial dispute, or the issues related to contract labor can also be considered as industrial dispute. What happened in the first case law? That is KK Tilakam versus Fact Limited. Here what happened? There was a public sector company and few employees were working as contract laborers. Now, here in this case law, it was held that the contract laborers working for the public sector cannot be considered as public sector employees, and they are the employees of that contractor only. So, they cannot raise any kind of industrial dispute. That is what held in this case law. On the other hand, a very beautiful and very interesting case law, that is Standard Vacuum Refinery Company of India versus their workmen. Here what happened? few permanent workmen of Standard Vacuum Refiner Company put a case against management demanding for abolition of contract labor system and to extend the privileges to the contract labor also. Here, Supreme Court used three important terms and said if they are available, then that case can be considered as industrial dispute. What are the terms? If there is a real and substantial connection between the people who are raising dispute and the aggrieved people, that is there because here all the employees were working together. Second one, if there is community of interest, that means substantial number of people are interested in raising such dispute, which was also there. And then finally, if the relief is possible, that means if the employer can give the relief to such workmen, in that case that can be considered as industrial dispute. As all the three were present in that particular case law, that case law was considered as industrial dispute. The next case law is concession versus service condition. This is a very important case law and a relevant case law that every industrial relation manager should know. Now what happens in the companies, there is a practice of giving privileges to the union office bearers because they being the office bearers, they will have certain amount of duties related to their union and management usually gives certain relief to them. Now these reliefs, whether they should be considered as concession or the service condition. Now if it is considered as service condition, then it comes within the frame of industrial dispute. If it is considered as concession, then it cannot be industrial dispute. So we need to understand whether such privileges given are concession or service condition, which is what exactly discussed under the case law of Workmen of Indian Bank versus Management of Indian Bank. Here what happened, the privilege of duty relief was given to few of the union office bearers and later for some reason they have withdrawn it. Now the union office bearers got upset and they tried to put an industrial dispute against the same. However, it was held in this case that they are only concessions and they are not service conditions and hence there cannot be any industrial dispute. I hope this gives a very clear clarity on the subject matter. With that, I am moving on. Now let's come to the last part of the definition, which is quite tricky also. That is, who is any person in the definition? Now the definition says of any person. Now can it be any person? Now that is what discussed under the workmen of Dimakuchi Tea Estate versus the management of Dimakuchi Tea Estate, or it is also known as Assam Karamachari Sangh versus the management of Dimakuchi Tea Estate. What happened here? Let's try understand the fact of case. A medical officer was being recruited by the management of Dimakuchi Tea Estate and he was under probation period of 3 months, and only after the satisfactory completion of his probation he would have been confirmed. But for some reason the management was not happy, so they paid him a notice period pay and terminated him. Now he went back, but the Assam Karamachari Sangh was not happy with the management decision and they tried to raise an industrial dispute. Now the question was, can that doctor taken under any person or not? If he can be considered as any person, then it will become industrial dispute. But if he cannot be considered as any person, then it cannot be industrial dispute. And in this case, Supreme Court held that the expression any person occurring in the third part of the definition of an industrial dispute as given in section 2K cannot mean anybody and everybody. That is very clear. The expression was held to mean a person who may not be a workman, but he may be someone in whose employment, terms of employment or conditions of labor the workmen as a class have a direct or substantial interest with whom they have under the scheme of the Act community of interest. Now here a medical officer does not have any direct or substantial interest with the scheme of their act or the Workmen's Act. That is why it was held that the medical officer cannot be considered as any person. I hope that is very clear. Now, saying so, it also gave four important limitations when any person cannot be considered for the party for industrial dispute. They are: only when there is a real and substantial relationship with the parties of the dispute, then it can be, otherwise no. Second one, they should have direct relationship with the particular establishment or party, otherwise it cannot be considered, or any person cannot be considered as party of industrial dispute. And such dispute must be related to employment, non-employment, terms of employment or conditions of labor. Only then it can be considered. And finally, if the parties are either personally interested or as a general interest of labor welfare, then it might be considered or not. Now, these are all the conditions that Supreme Court has laid down to consider any person as a party of industrial dispute. Quite tricky. Most of the time it is very difficult to prove that such person has direct connect with the establishment and he is coming under the definition purview of section 2K. Only if it is satisfied, then any person can become the party of industrial dispute, otherwise no. The last part that I am discussing is industrial dispute versus individual dispute, or when can an individual dispute can be considered under an industrial dispute. Now here what happens, the section 2A which came in the year 1965 gave a lot of clarity on what is individual dispute and when it becomes industrial dispute. But as a student, you need to write the history also, so that I am giving these case laws. Now in your practical life, I don't see any of that question arises, because section 2A very clearly defines when can an individual dispute can be considered as industrial dispute. But this is for your exam, I am giving these case laws. The first case law that I am discussing here is Central Provinces Transport Services Limited versus Raghunath Gopal Patwardhan. Here the court held three important statements. The first one is a dispute between an employer and a single workman cannot be an industrial dispute. So it says in the first statement that if there is a dispute between employer and a single workman, then it cannot be industrial dispute. But in the very second statement, it says it can be an industrial dispute. That means it is again case to case basis. And finally, it says it cannot per se be an industrial dispute, but may become one if taken up by a trade union or a number of workmen. So basically what you need to understand from these three statements, if there is an individual dispute which is being supported by the substantial number of workmen, then it can become industrial dispute also. That is all about this case law. I am straight away taking you to the last case law here, that is Workmen of Indian Express Private Limited versus the management. Here there were 31 employees who got terminated out of 68 employees. Here in this case, because there were substantial number of workmen who supported the cause of the aggrieved parties, the individual dispute was considered as industrial dispute. That way you can see the link between Central Provinces Transport Services Limited versus Raghunath Gopal Patwardhan and the Workmen of Indian Express Private Limited versus the management. Now these are the two case laws. Now let us try understand the all important, the Newspaper Limited versus the State Industrial Tribunal. What happened here, there was a person by name Tajamul Hussain who was working for the Newspaper Limited. Now one fine day he got terminated. Now none of the workmen objected the management's decision of terminating Tajamul Hussain. Rather, the union welcomed the decision of management. Now no one supported Tajamul Hussain. Rather, any nearby industries which are connected to the newspapers limited also supported to Tajamul Hussain. But one union from UP, that is UP Working Journalist Union, took the case and put a case in the court. Now it was held by the court that workman here is singular in sense and act speaks about plural sense. That was the first discussion point. Whether workman, that is WORKMAN or WORKMEN. Now if it is singular, then it is not an industrial dispute. But if it is plural, it may be considered as industrial dispute. That was the first thing told. But that doesn't make any sense now after section 2A. That is the importance of amendment section. And then it also said that union which is fighting the case doesn't have any direct or substantial interest in the case. That is a very, very important observation that we need to remember and should mention in our answer, that there was no direct or substantial interest to the UP Working Journalist Union with Tajamul Hussain case. So it was held that it is not an industrial dispute. If you need more case laws for the industrial dispute versus individual dispute, you can also refer the case law of Jagdish Narayan Sharma versus the Rajasthan Patrika Limited. Now, there are a lot of case laws available, but time is a constraint. I hope I have given clarity on certain aspects in this particular video. With that, I am concluding. I will come up with one more topic in my next session. Till then, thank you so much for subscribing my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are watching my channel, and thanks again.